Let's talk about crimes that have stemmed from domestic violence. Stalking is one of those. The book suggests that there are separate crimes that punish conduct that occurs between family members or people in special relationships. That's actually not particularly the case. While there are some laws that were created as a result of domestic violence, they apply to everyone equally, like stalking. And another one I'm going to add that isn't part of the reading, but it's important, and I think it needs to be dropped in this topic. So what actually changes, though, in these types of crimes like stalking? It was created as a result of domestic violence and reforming laws, but stalking can apply to complete strangers too. But what happens is it changes, depending on the special relationship, may change the crime grade, and hence the penalty can be enhanced when the victim and the defendant were in a special relationship, like husband and wife, boyfriend and girlfriend, or partner and partner, siblings, parent and a child kind of thing. The reason for this was that law enforcement was reluctant to get involved in family fights. So victims were not adequately protected. You will find these types of statutes that incorporate the special relationship within the assault charges, within the homicide charges, within the rape charges, and the ones that we are going to look at now and going forward. Stalking, strangulation is the one I'm going to introduce, kidnapping, and false imprisonment. So let's start with stalking. The first state to pass a stalking law was California. Think about that for a second. Why would California be the first state to create a stalking law? It's also, on a side note, it's also a law that is consistently misunderstood and misplaced. Some folks use this, "you're stalking me," and using this term stalking kind of liberally. But who lives in California? Lots of celebrities, and sometimes their fans become infatuated with them, and they're constantly trying to contact them, follow them, befriend them, profess their love to them. And there was no law really protecting this type of unwanted contact. And what prompted this action was a case involving actress Rebecca Schaeffer, who's pictured there, who was murdered by her lovesick fan, Robert John Bardo, who is the other photo there. After writing numerous letters to Schaeffer, Bardo attempted to gain access to the set of CBS, where she was filming in her TV show, My Sister Sam. This happened, by the way, in 1989, in which Schaeffer played a starring role. Ultimately, he obtained her home address via detective agency. So he hired a detective agency to get her address, which in turn tracked it to California Department of Motor Vehicles records. And on July 18th, 1989, he confronted her at her home. He was angry that she had appeared in a sex scene in a film called Scenes from the Class Struggle in Beverly Hills. And in his eyes, she had lost her, quote unquote, she lost her innocence and became another Hollywood whore. He visited her at her apartment and told her he was a big fan. After being turned away by Schaeffer, he stopped at a diner for breakfast, only to return to the apartment about an hour later, ring the doorbell again, and when she opened it, he shot her in the chest. So this was a huge case. California did get some national news because she was a famous actress. But that really hit home, stalking. Even though stalking existed in the domestic violence world, this was what kind of launched it. And then other states followed suit. And the purpose of the stalking laws is to prevent defendants from completing the other topic we talked about, the assault and battery, right? That gets us to, like, if there was stalking statute law in place at the time of this incident and his conduct of, writing her letters and such, would she have been shot? Would you have gotten that, or, murder in this instance? So, side note, by the way, on this case, before I leave it, the prosecutor in this case was Marcia Clark. And if you're not familiar with that name, right after she prosecuted and won this case, he was convicted of murder, John Bardo. Her next case was prosecuting O.J. Simpson. So Marcia Clark was pretty busy back in the day. Just to continue along, stalking laws just are not for women only. They're gender neutral, but statistics show that women more than men are the victims of this crime. So what do we need? We need a criminal act, any course of conduct that credibly threatens the victim's safety. So what can be course of conduct? There's a whole slew of things that can be a course of conduct. Just think about it, right? I got a bunch of them up there. Pursuing, following, showing up places. You don't have to say anything, but certainly expressing or implicitly making threats to the person or to their family members. Constant phone calls, voicemail, text, email, instant messenger, Facebook posts, social media posts in general. Well, old school was sending letters. That's the only way you get celebrities, right? Sending letters. Course of conduct. What does that mean? What does that suggest? If you send one letter or one text, is that going to get you stalking? Probably not. You definitely need more than once. Twice, maybe. In New York, 3 times will get you there. So things to think about. In that example that we just talked about, that case I just talked to you about with Rebecca Schaeffer, he wrote letters. He obtained her personal information from a detective agency. Like, he went all out. And he showed up at her house. That was that information outside of what he did afterwards, but that is by far more than enough to get course of conduct that constitutes stalking. Criminal intent, intentional. This is a specific intent crime, intentionally sought to cause the harm, which is, what is the harm, by the way? What would be the harm? Fear, putting the victim in fear or threatening their safety. That's the goal. You don't have to actually harm the person. Some statutes say intimidate, put them in reasonable fear. Any course of conduct that threatens the victim's safety, that's the general definition. If you do, what if you send somebody a bunch of text messages? Is that really stalking? No, you need to actually put them in fear. You could be annoying with your text messages, but unless you put them in fear, at least what we're talking about right now, that might change when I read you some statutes. That's why you'll see that this is a very misunderstood statute. So defendant causes that fear. Fear of what? Fear of not being safe, fear of death, being seriously hurt, have a family member being seriously hurt. So fear is the magic harm when you take on a course of conduct. The New York Statute, let's talk about this. Stalking in the 4th degree, which is the lowest level stalking in New York. So it's a misdemeanor. When he or she intentionally and for no legitimate purpose engages in a course of conduct directed at a specific person and knows or reasonably should know that such conduct is likely to cause reasonable fear of material harm to the physical health, safety, or property of, and that would be that person. What do you think of this? Our act Course of conduct, our criminal intent. We got a few intents here. You have to intend the course of conduct, and you have to know or reasonably know that that conduct is going to place the other person in reasonable fear of harm of their self, safety, or property, and that should say of themselves or another. I don't know why I didn't finish typing that out. And that's just a misdemeanor. What about, I'm going to show you one more statute, and then we're going to expand a little bit here. So this is New York's overall misdemeanor level statute on stalking. I'm going to cover one more type of stalking, which New York does not distinguish. So when we look back at those examples of what constitutes a course of conduct, if you're sending text, voicemail, social media content, what else? What did I miss? Showing up at places, mailing letters, all of those things will constitute a course of conduct in New York. California has a separate spin-off of stalking. They actually make cyber stalking its own crime. So it makes it a crime to stalk someone by means of an electronic communication device. So if you're using your phone to do text messaging or emailing or instant messaging or social media, in California you'll be charged under a cyber stalking statute. New York's general statute and those that go up in grade and cover it all. They encompass it all, regardless of where your communication, where the defendant's communication comes from. All right, I want to give you an example. California has the best examples. I should get some more out of there. A mere 3 weeks after their cyber stalking law passed, there was a fellow, Gary Della Penta. He was charged with using the internet to solicit the rape of a woman who had rejected his advances. He terrorized this woman by placing ads in her name that claimed she had rape fantasies and provided her address and instructions for disarming her security system. At least 6 men saw the internet ad and came to the woman's home. Many more called with obscene messages. On January 1st, 1999, California passed this law, and he, by his conduct of doing this, of using the internet to get back at her, had repeatedly, because she repeatedly rejected his romantic interest, the woman had no idea why these men were banging on her door in the middle of the night, saying they were there to rape her. When she finally learned about the internet ads, she placed notes on her door explaining that the ads were false. However, this guy jumped right to it and said in his new ads saying that the notes were part of the fantasy. He was finally caught when the victim's father pretended to respond to the ads and traced the origin. And he was charged with this cyber stalking. And because of the content of what his posts were, they were sexual in nature, he was charged with solicitation. Remember our solicitation when you try and get people to commit crimes for you? Solicitation of sexual assault. Ultimately, he's got a 6-year prison sentence for that kind of conduct. And he didn't even he didn't follow her. He didn't send stuff directly to her. That's a course of conduct, what he did in his actions. That would have constituted a stalking charge in New York as well. But I'm just a couple examples there. One, to show cyber stalking, but number two, you don't have to actually direct your communication at the person, directly at the person. Grading. There's various levels of grading for stalking depending on a number of factors in New York State. There's many levels. That one I read you is a B misdemeanor, which is very, very low on the totem pole for penalty. but it's also quite broad, right? Any unwanted contact can constitute a stalking if the victim's placed in fear. But they go up in grade depending on who the victim is and the defendant. Are they related or are they strangers? What did the defendant use to create the fear? The harm that actually resulted, and if the defendant had been convicted of stalking in the past. So in New York, we can range from a B misdemeanor to a C felony on stalking. Now there's another charge, if we're talking about charges that come from domestic violence or stemmed from domestic violence. This is New York's law on strangulation in the first degree. Not many states have a separate strangulation. It falls under the assault category, but it, as a result of, you know, the research that was done relative to crimes in domestic violence, 10% of women were strangled to death by their partners or significant others, which prompted New York State to pass legislation on specific legislation and laws on strangulation. There are 6 states that do not recognize this: North Dakota, Ohio, South Carolina, Kentucky, Maryland, and our capital, D.C., does not recognize strangulation as a separate offense. But it does in New York, and it is a C violent felony, which could land somebody in prison. I believe it's mandatory prison sentence. And I think the maximum is 5 years. 7 years. Strangulation in the first degree, when with intent. So our defendant has to have intent to impede the normal breathing or circulation of the blood of another. He or she, this doesn't have to be a domestic violence case. This can be 2 people in a fight and somebody puts their hands around somebody's neck. They apply pressure on the throat or neck, or they block the nose and mouth, and thereby causes the person serious physical injury. It was found in the research on strangulation that even if the victim didn't die, they suffered serious brain damage or other significant injuries as the result of having loss of air for a period of time. So make sure you know, put that one in your arsenal, strangulation. And our next topic is kidnapping and false imprisonment.